speaking with me, Tarun Nandia. Now we resume part two of our series on the life and times of Soli Sorabji, which is based on a book penned by Advocate Abhinav Chandrachud. If I want to do a small recap, in part one, you saw Abhinav Chandrachud sharing with you, tracing Soli Sorabji's life from his family first, his grandfather, then his father, and then Soli's early school days, high school days, and college days. In part two, we will discuss his, in a sense, his venturing into the profession of law, and then his early days, and then his whole life. Welcome, Abhinav, and good to see you again in part two.
Likewise.
And now, so when did you think that Mr. Sorabji decided to pursue a career in law?
So really, one of the incidents in his life, really, which had a very lasting impact on his career and on his future, really, was the death of his father when he was 19 years of age. His father, of course, had married very late in life. There was a gap of around 20 years between his father and his mother. And when his father died when Sorabji was 19 years old, all the responsibilities fell on Sorabji. Sorabji, of course, was an only child. Mm-hmm. So he had to go to the office of the executor of his father's will. And it was there that he was treated very roughly. It's not very clear what exactly happened, but Sorabji was made to stand, he was made to wait, he was made to kowtow to this person who was the executor, some member of the family. And it was there that Sorabji decided that he wanted to do something where he would not have any boss. He wouldn't have to kowtow, to use his own language, to any board of directors. And he wanted to be an independent professional. And the career that he picked for himself, his mother was keen that he might do something in accounts, but he was very keen on pursuing the career of law, a career in the legal profession. And really, that's when he decided that he wanted to be a lawyer, to be his own independent person, to speak his mind without really having any boss sitting in judgment over what he's going to do and what he can't do.
But I think this is quite tragic that losing a father at 19 for anyone, it's not about Soli Sorabji, can be quite tragic. Do you think that hardened himself for future life? This was a changed man at the age of 19, and law empowered him in that sense, knowing law, as it all says, giving a feeling of confidence to people. Do you think it changed him? And that is why he decided law? I'm just trying to understand what you soaked in while talking to him.
Well, more than anything else, I think that we shouldn't be too quick to judge a person by that person's family background or by that person's the wealth in the family or whatever it may be. Because in part one, I began by saying that, well, Sorabji was born to a Parsi family of substantial means. He was a privileged person. But after all, what is privilege? Here is a person who's lost his father at the age of 19. That's a deep tragedy for anybody. So yes, he was privileged. Yes, he was born to a wealthy Parsi family. He didn't have to worry about money in his initial days at the bar. Right. Then again, he didn't have anybody really to guide him. His father, he lost his father at the age of 19. Really, he was a first generation lawyer. One of his cousins was married, if I'm not mistaken, to his senior at the Bombay bar. But really, he had to do it all himself.
Now, he then became a lawyer at the Bombay High Court. And could you share some early anecdotes of the Satwant Sani case and the Mayor Hans case? Could you share what were these cases became very famous?
Yes, absolutely. In fact, these were some very interesting cases. If I'm not mistaken, the Mayor Hans George case was decided by the Supreme Court in the year 1964, when Sorabji was 34 years old. It was Sorabji's first reported judgment in the Supreme Court where he himself was arguing a case. Of course, Sorabji had gone to the Supreme Court before. He had also appeared in a reported judgment before, but he had not argued the case himself. So this was really his the first time that he was standing up in the Supreme Court in a case which became important enough for the judges to have the case reported, the judgment reported. Now, the Mayor Hans George case was about this notorious smuggler. By the name, he was a Swiss national, if I'm not mistaken, and he was smuggling gold from Switzerland to the Philippines, if I'm not mistaken, and he was transiting through Mumbai. And the customs department really acted on a tip. When the flight landed in Mumbai, they approached this man and they asked him whether he was carrying any gold. He said that no, he wasn't. The customs officials took him out of the plane, and they saw that he was wearing a special jacket which had some 20 odd pockets in it on the inside, where he was carrying gold. Now, what Meyer Hans George argued right from the very bottom, and Sorabji represented him in the Bombay High Court where he won, and then in the Supreme Court where he lost. What Sorabji argued was, and Sorabji was assisted in that case by his junior Avinash Rana, and what they argued was that, well, there was a law in India that if you're transiting through the country, then really it's not considered smuggling. If you're carrying gold through the country to another country, then it's not considered smuggling. You're not bringing the gold into India. But that notification had been repealed in 1962. Only that notification, which repealed the earlier law, could not be found anywhere. So Avinash Rana looked high and low in the library at the Bombay High Court and couldn't find this notification anywhere. So Sorabji argued that, look, if we could not find this notification in the Bombay High Court, then how could Meyer Hans George be expected to find it sitting in Zurich? So the argument really was that ignorance of law is an excuse, in other words. And the Bombay High Court accepted this argument. The Supreme Court said, no, nothing doing. Once the notification is published in the official gazette, then whether you have access to the official gazette or not is irrelevant. Ignorance of law is not an excuse. And the moment something is published in the official gazette, that's good enough to bring that law into effect. Now, interestingly, that case was decided by a bench of 3 learned judges of the Supreme Court, one of whom was Justice Subba Rao, that is before he became the Chief Justice of India. And as a puisne judge, Justice Subba Rao was a great dissenter. He dissented in perhaps the highest number of cases in which any Supreme Court judge has dissented. And the great irony is, once he became the Chief Justice of India, he rarely dissented, if ever, because the Chief Justice of India in our country has the power to select benches. And so really what Subba Rao is, the legend has it that Subba Rao told a great scholar in the US, scholar by the name of George Gadbois, when Gadbois asked him that, how is it that you've not dissented as the Chief Justice? Legend has it that Subba Rao jokingly said that, well, that's because I selected the bench. So I selected the judges who would agree with me. But the point is that when Subba Rao then became the Chief Justice, Sorabji had the opportunity in 1967, when he was 37 years of age. By the way, at the age of 37, 50% of Sorabji's reported judgments were delivered by the Supreme Court and 50% by the Bombay High Court. So 14 years into his law practice, Sorabji was already had a substantial foothold in the Supreme Court of India. And in 1967, when he argued the case of Satwant Singh Soni, his client was an importer. He was prevented from going abroad for fear that he might evade some customs law in India. And Sorabji said that, look, you can't really decide at your whim and fancy whether to give my client a passport or not, because Sorabji argued that the right to travel abroad is a fundamental right, a proposition which he had argued previously in the Bombay High Court and succeeded in. The Delhi High Court was the only High Court which had taken a contrary view. The other High Courts in India, if I'm not mistaken, Kerala, Bombay, and one more court, had taken the view that the right to travel abroad is a fundamental right. Delhi High Court had said, no, it's not a fundamental right. So Sorabji convinced the Supreme Court that the right to travel abroad is a fundamental right. It's a part of the right to personal liberty under Article 21. And Article 21 says that the right to life and personal liberty can only be taken away by a procedure established by law. So unless there is a law laid down by Parliament, which tells us when a passport can be impounded and when it cannot be impounded, the government officers can't at their own whim and fancy decide when to impound Satwant Singh Soni's passport and when not to. And this time, of course, Subba Rao was the Chief Justice of India. Justice Subba Rao really was the one who was presiding over the bench in Satwant Singh Soni's case. And he had agreed with Sorabji in Meyer Hans George's case. He continued to agree with Sorabji in Satwant Singh Soni's case, and that really became the law of the land, which continues to hold the field today. It was a constitution bench that the right to travel abroad is a fundamental right, and that right can only be taken away by a procedure established by law and really not by executive whim and caprice.
Now, emergency is a landmark movement in our history as far as the history of post 1947 India goes. After we attained it, emergency is remembered. Of that period, how did Sorabji go through those 2 years? Could you share that with us in the next 2.5, 3 minutes?
Sure, absolutely. So what Sorabji wrote about the emergency was that the people of India were accustomed to living in emergencies. There had been emergencies during the war with Pakistan, during the war with China. But this emergency that was imposed by the Indira Gandhi government in the mid-1970s was different for at least 2 reasons. The first is that press censorship had not been imposed in any of the 3 previous emergencies. like it was during the Indira Gandhi emergency. And secondly, never before were opposition leaders arrested in the manner that they were during this emergency of the 1970s. And the censor acted in a very odd manner. So quotations of Gandhi, Tagore, and Nehru were blacked out. There was an actress, a very famous Indian actress, who was allegedly arrested in London on allegations of shoplifting. That news story, for some reason, was not allowed to be carried by the censor in India. Journalists were extremely afraid. There was a prominent journalist by the name of Kuldeep Nair who was arrested. And that really sent a chill down the spines of many journalists. And journalists, many of whom complied with the government, got favors from the government. They got newsprint, they got government advertisements, they were sent as part of official delegations abroad. And really, Sorabji was, of course, opposed to the emergency, but he was ostracized by many of his friends who believed that the emergency was a good thing, that it would bring much needed discipline to India. And the emergency really altered fundamentally Sorabji's law practice. Until then, he was in a very large way a customs and excise lawyer, and the constitutional cases that brought him to the Supreme Court were really, in a sense, customs and excise cases. But for the first time in his career, in a very large way, he started appearing in criminal cases, particularly in habeas corpus cases, where he appeared for Indira Gandhi's political opponents and tried to get them released by the courts. And it was, of course, a very interesting time. He wrote letters in code because he was afraid that those letters might be intercepted. So his son Jahangir would type out the letters in code. His junior Avinash Rana also told me that he would never sign his name. But when you received that letter from him, you knew that it was from Soli Sorabji. And Sorabji, of course, at that time was also working on a book on freedom of speech and expression. And the real idea of writing that book was that the censor was not publishing or was not allowing many law reports or newspapers or periodicals to publish judgments that had been written that were anti-government judgments. So judgments that were pro-free speech, judgments where people who had been detained were released. So Sorabji's idea in writing that book on free speech was to publish an appendix which would contain a compendium of all those judgments that could be relied upon by journalists and lawyers in really advocating the cause of freedom of speech and expression.
Very interesting. Soli appeared for a lot of people who were incarcerated during the emergency.
Oh, yes, absolutely. Absolutely. And that free speech manuscript of his, he kept with his aunt because he was afraid that that manuscript might be really, in that sense, confiscated by the government.
There's an interesting anecdote about Taj Mansingh Hotel in Delhi in your book. What is that about?
Yes. So this is, of course, after the emergency. Soli Sorabji became the Additional Solicitor General for India. He was asked by Law Minister Shanti Bhushan. He accepted after having a discussion with his wife. And he went to live at the bungalow of the Additional Solicitor General at Motilal Nehru Marg. If I'm not mistaken, that is now the residence of the Attorney General of India. And that bungalow is just, it neighbors the Taj Mansingh Hotel, which was being built at that point in time. And that hotel, legend has it, rumor has it, was being built night and day. The construction activities did not stop at night. And Sorabji, of course, wanted to get some sleep. He tried calling up the Taj Group several times to request them to kindly stop the construction, but his protests and requests fell on deaf ears. So legend has it that Sorabji was a talented mimic. This, of course, is a well-known fact. And the Italian ambassador to India used to live just down the road from Sorabji at that time. So one night when Sorabji was unable to get some sleep, he called up the Taj Group and imitated the Italian ambassador. And in that Italian accent, he asked the Taj Group to kindly halt the construction because it was causing too much noise at that point in time. And I think the Taj Group got the hint. So they then went into his residence and soundproofed his bedroom so that they could continue their construction activities and Sorabji could get a peaceful night of rest.
Now, can you tell something about Sorabji's first stint as the Attorney General of India?
Well, yes, it was a very interesting time. He became the Attorney General of India for the National Front government. And really the point was that he wrote, he was interviewed or he gave a statement to the press where he was around 59 years old. And he said that he would not be the hatchet man of the government. His duty was to the people of India and not necessarily only to the government. And when Palkhiwala read this, he was extremely pleased. And he wrote a letter to Sorabji saying that I was initially going to congratulate you when I heard that you're going to become the Attorney General of India. But now I want to congratulate the people of India that they have found an Attorney General in a man like you. But Sorabji's tenure as Attorney General for that 1 year with the National Front government from 1989 to 1990 was not an easy one. Of course, it was the first minority government in India's history. That was VP Singh's Janata Dal government had secured, the Janata Dal party had secured around 143 seats, which was significantly short of a majority in parliament. Sorabji had to argue the Mandal Commission case in 1990 when the Mandal Commission report was really operationalized by that government. And Sorabji very fairly informed the Supreme Court that it would take 2 or 3 months to implement the Mandal Commission. And relying on that statement, the Supreme Court decided to stay the implementation of the Mandal Commission report pending the hearing of the case, the Indra Sawhney case. And after this happened, Sorabji's effigy was burnt by the supporters of the Mandal Commission report because they felt that he had not argued the Mandal Commission case effectively enough. One of the most significant cases, apart from the Mandal Commission case that Sorabji argued as the Attorney General with the National Front government, was the Bhopal review case. Of course, the Bhopal gas tragedy remains to this day the world's worst industrial disaster. Nearly 4,000 people died, over 18,000 were permanently injured, some 1.73 lakhs were temporarily injured. The Bhopal case had been settled, and Sorabji had written in the press that it had been settled in a manner that seemed like it was a cloak and dagger affair. One fine day in the Supreme Court, the judges suggested that why don't you settle this case, and it was settled. And the prevalent sentiment in the public was that the amount that had been agreed upon was far too less, and the government had not filed a review. The review had been filed by some private individuals. But with the change of government, when Sorabji became the Attorney General, the government decided to support the review of the Bhopal case. And eventually what the court found was that they were not going to reopen the settlement, but they decided to restore the criminal cases that had been filed against the management of Union Carbide. And they said that, well, the central government would have to take out a group insurance policy for the victims of the tragedy. They said that Union Carbide would have to pay for a new hospital in Bhopal. And really, one more thing that I would want to say about his time as the Attorney General is that he was not consulted by the government on many issues. This is something that I realized. So I doubt whether he was really consulted on the implementation of the Mandal Commission report. Really, that was an interesting fact that I was able to find.
Now, because there was another legend of that time, senior advocate Ram Jethmalani. What kind of relationship that these two individuals have, Soli Sorabji with Ram Jethmalani?
So I would say that they began as friends, but thereafter they had a very difficult equation when Ram Jethmalani became the law minister and when Soli Sorabji was the Attorney General of India. And this all goes back to the Sri Krishna Commission report. December 1992, the Babri Masjid was demolished. Communal riots took place in Bombay. The Sri Krishna Commission was constituted, and the Sri Krishna Commission made some recommendations, compensating the victims, prosecuting errant policemen, reopening riot-related cases. A case was then filed in the Supreme Court seeking to implement the Sri Krishna Commission report. And in that case, the central government, that is the BJP-led coalition government, filed an affidavit saying that law and order is a state subject, and therefore we really are neutral. We can't really implement the report. We have nothing to do with this report. But while this case was going on in the Supreme Court, Ram Jethmalani, who was a cabinet minister, and one more minister made statements to the press that one prominent politician in Mumbai, could not be prosecuted for his alleged role in inciting the riots because the case against him was time barred. Now, when the case came up before the Supreme Court again, the case to implement the Sri Krishna Commission report, the Chief Justice of India at that time, Chief Justice A.S. Anand, came down on Sorabji very heavily. He said, is this any way to run a government? On the one hand, you file an affidavit in the Supreme Court saying that you are neutral, you are the central government, the implementation of the Sri Krishna Commission report is a state subject, and so you have no powers. And on the other hand, your own ministers go out into the press, into the media, and make statements saying that, well, the case is time barred, and so how can the Sri Krishna Commission be implemented now? So is there some such thing as collective responsibility or not? And Sorabji, the one reputation that he had was that he was never the mouthpiece of the government. He was always an independent lawyer who answered really true to his conscience. So sure enough, he stood up in the Supreme Court and said that he completely agreed with the judges. He did not come to the defense of the ministers that the Chief Justice of India was criticizing. This, of course, was reported very extensively in the press. And what happened was that Jethmalani was then forced to resign. by Prime Minister Vajpayee. Thereafter, this left a very bitter taste in the mouth of Jethmalani, who wrote a book called Small Men, Big Egos, where he really came down very heavily on Sorabji. He criticized him for some of the decisions he had taken as the Attorney General of India. So yes, the equation between Sorabji and Jethmalani was a difficult one. And I've written about much of this in the second last chapter called Coalition Dharma in my book.
Okay, point well taken. I'll go to what are some anecdotes or facts, let me call them facts in the book, which you think people will take notice, a few if you can share with us, or something which will cause people to mull over.
So that's a very interesting question. And I would say that there are about three things that are broader questions that we may want to ask ourselves as a legal profession, as a civil society. And the first fact that emerged from my research in the book was that when Sorabji was a private lawyer, whenever he argued cases as a private lawyer, he won around 50% of those cases. I'm of course talking about the cases that were reported, they were reported judgments. Sorabji won around 50% of his cases as a private lawyer. But that win-loss ratio went up substantially when he became a government lawyer. So around 70% of the cases that he argued as a government lawyer were cases that he won, the balance being cases that he lost. Another question, one of the questions I've asked myself in the book is that why is it that Sorabji's win-loss ratio, and these are data that I've collected myself by going through the law reports myself and counting victories and losses myself in cases where there was a readily identifiable victor and loser. Why is it the question I've asked myself that every time Sorabji became a government lawyer, his win-loss ratio improved? Surely his advocacy skills did not improve substantially when he became a government lawyer. And there are three possible answers that I've been able to come up with. Perhaps the government was a more responsible litigant. Perhaps Sorabji as a law officer had greater discretion to settle cases. And so he only decided to litigate the cases that were more easily winnable. And he decided to settle cases that he knew the government had low chances of winning. Or another possible answer is that courts in India, regardless of which political dispensation is in power, tend to be more deferential towards the executive. After all, we have a principle in India that the presumption is that the law is constitutional when you challenge a law, and the onus is on the petitioner to prove that the law is unconstitutional. And this burden very rarely shifts, even in cases involving the highest of fundamental rights. Whereas in the US Supreme Court, they have something called a strict scrutiny test. That is where the very highest of fundamental rights are involved. The burden is on the state to justify that the law is in fact constitutional. So in India, really, that burden very rarely shifts. So that's one of the broad takeaways. The second, yes, sorry, go ahead.
One last question that I would want to ask you would be, can you tell me one or two takeaways for young lawyers from Soli Sorabji's life?
Oh, absolutely. I mean, there are so many things for young lawyers to bear in mind. First and foremost, Sorabji paced his innings in life. I would say that, of course, Sorabji wasn't very fond of cricket, but if you compare life to cricket, then Sorabji played his innings as though he was playing a test match and not a T20 game. He had interests apart from law. He loved taking his holidays in Mahabaleshwar and the UK. He was very fond of poetry and jazz. His best friends were non-lawyers. So he didn't burn himself out by working night and day as a lawyer in such a way.
Despite you're sorry to interrupt, but the book mentions that he had a hard start. Despite a privileged background, he couldn't easily get into law. He had a struggle, no office initially. His senior had no office because he barely had any space for himself. So it was not that easy.
Oh, absolutely. And he worked incredibly hard. There's no real substitute for hard work. So I'm not saying don't work hard, but the way in which Sorabji worked, he ensured that he had some interests apart from the law. That's the first point. Then there are some broader things that young lawyers may want to bear in mind after looking at Sorabji's life. He argued the majority of his cases himself. Between 1953 and 1970, 63% of his reported cases, that's before he became a senior advocate, were cases that he argued himself. He never depended on... I'm sorry?
He himself wanted to argue matters. He was
yes. Oh, absolutely. It's not that he only assisted a senior. Of course, assisting seniors is very important. It's like medicine. You get to learn a lot. It's medicine that you have to take. But Sorabji argued the majority of his cases himself. He was never dependent on any single client or any single law office or solicitor or attorney for his future. So if any single client or attorney decided not to brief him, that didn't make any difference to his life. He often cited cases against himself. So it's not like he tried to slip something past a court. It's not like he tried to obtain a favorable order from a court by hiding what the true position in law was. He was always very candid with the court. He made concessions on points that went against him. And really, his advice to young junior lawyers, I feel, would be never be the mouthpiece of your client. Prepare a detailed list of dates. Play the devil's advocate in a conference. Ask what are the questions that your opponent might argue in court? What are the questions that the court might ask you? Never raise your voice in court. Be respectful towards the court. Always answer the court's questions first. And do not draft pleadings aggressively. These are some of the things that his juniors told me that he used to insist as far as his own juniors were concerned.
So now we go to Mr. Ryan Karanjawala, managing partner of Karanjawala and Company. Now, you know Soli Sorabji and you knew Soli Sorabji, and of course the author of this book, Advocate Abhinav Chandrachud also. So in about the next 3-4 minutes, could you talk about both Mr. Soli Sorabji as well as what do you think of the book? I mean, this endeavor taken by Advocate Abhinav Chandrachud to come out with something like this.
So let me start with Soli, who I first met, or I first saw. And I want to talk about 3 aspects of Soli: the civil rights crusader, the law officer, and the private advocate. So I first saw Soli in 1976, somewhere in the winter of 76, when I was studying at Government Law College in Bombay. At that time at St. Xavier's College, there was a couple of speeches which were being made, all criticizing the emergency. You must remember that the emergency was on. People were scared to speak. Soli was one of those fearless people who was more than happy to speak on such occasions. And I remember going down to Xavier's College to hear him. And I still remember distinctly what he said. He said, look, there is no point in talking about emergency has improved, discipline and things like that. When you talk of discipline, you must mean discipline in the larger context, discipline in the matter of adhering to constitutional values. So it's something that always stuck with me. And one thing I can always tell you, Soli, whatever his persona, there was one aspect of him which was always there, which was that he was an extremely public-spirited person. Even during the emergency, he had appeared for a lot of the detainees, free of cost, obviously. My father-in-law was another person who Justice Tarkundu used to appear for them, and Soli and he became close at that time and thereafter. The second thing I remember about Soli is Soli the law officer, not so much Soli the Attorney General, with whom I'll talk about that later, but Soli the law officer as Additional Solicitor General. As Additional Solicitor General, one of the most memorable pieces of advocacy that I remember Soli giving was appearing in Chandrachud's court, that is the grandfather of the author of the book, in which he argued for Sanjay Gandhi's bail cancellation and succeeded. And among the many different pieces of advocacy that I remember, this was certainly one of them. I also remember Soli as an Attorney General, not so much in his second stint in the Vajpayee government as in his first stint in the VP Singh government. Because at that time I had some I was in close interaction with him. I was in interaction with VP also when the choice had come down to 2 people. It was either Shanti Bhushan or Soli Sorabji, and both VP and even all of us who had worked with Soli in the Fairfax Commission, where Soli had appeared for Bhurelal and all preferred, Arun, myself, everyone preferred Soli as the Attorney General, and Soli then did become the Attorney General. Now, talking about Soli, the private counsel. So, my most memorable remembrances of him are in the early years when I used to be practicing day to day in court and used to be when we were working with Praveen Parekh and later on even in our own independent practice. When we used to be in court every day, almost 3 times a week, we'd find ourselves out of the 5-day week in either Fali's office or Soli's. Now that court, Chandrachud's court as it was called, was a court which had a galaxy of talent. You know, there was Anil Diwan, there was K.K. Venugopal, there was P.R. Mridul, there was Dr. Y.S. Chitle, my father-in-law, Justice Tarkunde, Shanti Bhushan, Dr. L.M. Singhvi, Mr. R.K. Garg, who was a great constitutional lawyer. So there was a galaxy of talent. But two counsels dominated that court. They were both from Bombay. They were both from the same chamber. This is Kanga's chamber. And they were both Parsis. Fali Nariman and Soli Sorabji. And and between them, there was a deep, intense, and sometimes unfriendly rivalry. And the court used to be, and the briefing advocates used to be by and large divided into two camps, those who preferred Fali, those who preferred Soli. I and my wife were one of the fortunate few who were in both camps at the same time, because I had grown up in a sense in the Nariman household, being a close friend of Rohinton's, and Manek, because of her father, knew Soli from her childhood, from her early collegehood. So we were people who were fortunate in having had occasion to work with both of them. And it was a pleasurable experience. I remember if you went to Soli's office and you would reach there about 8:30 in the morning, he'd have 15 matters on hand. And you'd have to he'd already have done conferences in 6 or 7 the evening before, and now there were 7 or 8 matters to get ready in the short course of time. And Soli had a very distinct style of working. You would tell him a point, he'd note it. And he, unlike other counsels who always noted on the top of the brief, he would always note it on the last page. He would always just look at the last page and argue. And it's quick, short notes, this point here, this point here, this point here, this point here, this point here. And then on the basis of that crisp briefing of 10, 15 minutes, they could go and argue for an hour at a stretch if required. So they were the top dominant counsels of that time. And Fali and Soli was to be, I think, dominated the whole 80s up to the 90s. And then, of course, many more counsels came up and started doing well. Soli had also a very interesting stint in his second round as Attorney General. He's the only person I know to have been appointed Attorney General under 2 distinct governments, the VP Singh government and the Atalji government. So he's had an illustrious career. Now, as far as Abhinav Chandrachud's writing of the book is concerned, I'm very glad that he's written it. Because people who have been such legends do require to have themselves written about, and with people who have had so much talent. Abhinav is, of course, a practicing lawyer, understands the law well, is deeply steeped in the law, understands the traditions of the Bombay High Court with which both Soli and Fali were imbibed. And therefore, I think his book, I haven't yet read it, but I intend to get a copy and go through it, will be a fitting tribute to the man that he was.
Thank you so much for all sharing all the anecdotes and the inputs. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.